Hey y'all, Gary here with Tennessee Stands, and got some news for you, a little bit of an update, and some information that's really important for you to understand regarding our lawsuit against Governor Bill Lee and the state of Tennessee over the emergency power statute, which, if you remember, we filed this lawsuit back on August 27th of 2020. So it's been a while, and we're still fighting for our right just to be heard by the court. So just about a month ago now, and we've been working on some things before we updated you because there's a lot of things happening. But about a month ago, the court in Davidson County dismissed our case against the governor on standing. Chose not to even rule, but just threw it out on standing, and I'll get to that in just a minute. So we have filed a notice of appeal. So we're not backing down, by the way. We're not just letting this go. So we have filed a notice of appeal, and we're starting to structure our argument in our brief into appeal. But before I get to that, we had something very fortunate happen, I think, as if the Constitution isn't fortunate enough. A lawsuit was just won in the state of Kentucky, filed. The final order was filed on June 8th, just a few days ago. And a circuit court judge in the state of Kentucky ruled that Governor Beshear's executive orders per their emergency power statute was unconstitutional. And they argued the same basis again, just like they did in Michigan. If you remember, there was a lawsuit that went to the Michigan Supreme Court that ruled that their executive orders on their emergency powers was also unconstitutional. And again, we have filed our complaint on the same basis here in Tennessee because we have the same provisions in our Tennessee Constitution that should protect citizens from a governor or any executive purporting to create law in this state. Why? Because governors don't make laws. Legislatures make laws. But I want to pull out some things from this ruling in Kentucky that I thought were some really great statements. So let's take a look. First off, the judge acknowledges that what happened, which is what we've claimed here in Tennessee due to our separation of powers clause in our Tennessee Constitution. The judge acknowledges that by making executive orders, that the legislature has attempted to delegate functions constitutionally reserved to the legislative branch. Here's what that means. The Constitution says that governors execute laws and legislatures make laws. That means that the legislature is not allowed to delegate its lawmaking power to the executive branch, because the Constitution says you can't do that. So it doesn't matter that in an emergency, the legislature pretended that the governor can make law. The Constitution simply forbids it. Let's keep going. Let me scroll down here to, So this I just thought was a phenomenal statement mounted by the defense. Listen to what they say in this court order. The Great Charter of Tennessee and is its Constitution. And its guarantees are sealed by an oath, one that applies to all offices in all branches. Before a person may take office, regardless of whether the person is elected or appointed, the individual, among other avowals, must formally declare, "I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of this Commonwealth, and be faithful, true, so help me God." By the way, before I finish reading this, we have that same provision in our Tennessee Constitution, almost verbatim, and that is the same oath that our governor takes when he takes office, and it's an oath that all of our representatives and senators, sorry, I can't talk today, all of our legislators take here in the state of Tennessee. So we have the same oaths here, just so you know. Continues to say, the Constitution places limits on what government may do to and for its citizens. All the laws enacted by the General Assembly and all laws enforced by the executive are subject to those limits. The result, as John Adams put it, is a government of laws, not men. This is such an important concept. It's something that you have heard from me and from Tennessee stands over and over and over again. If you've been to any of our rallies or any of our events, we simply say this: we must hold our elected officials accountable to only the authority which they are given by the people per the Constitution. Just because someone is elected doesn't mean they have absolute authority to do whatever they want to do just because they think it's a good idea. Their authority is limited only by the authority that we have given them. That's exactly what this is saying in this court opinion. Let's read this final statement here I wanted to take you to, because it's important here. So here they're talking about the orders that were made, the executive orders that were made by the governor. Clearly, because, by the way, this has been an argument from the other side, from the Attorney General, that executive orders are not laws. Oh, we didn't make any laws. The governor just made executive orders. Well, that's not the way this judge in Kentucky saw it. Clearly, what has been ordered by the governor's emergency decrees constitute legislation. Dr. Stack's testimony demonstrates that he and others engage in a process of collaboration and review of CDC guidelines and other documents, the purpose of which is to impose rules on persons and businesses in Kentucky, and that in formulating these rules, they tailor them to apply uniformly across the Commonwealth. When you make a rule or an executive order or a regulation, doesn't matter what you call it, and you apply it over the whole of the people, and then you create a penalty if the people disobey, guess what that's called? A law. That's the way this judge, that's what we've been saying all along. That's a law. Guess who can't make laws? Governors. Let's continue. It's obvious from even a cursory review that the orders issued over the past 15 months attempt to control and seek to form and determine future rights and duties of Kentucky citizens. These included, by the way, which we did some of these same things here in Tennessee, no matter what the governor tells you, either the governor did it himself by executive order or he delegated the authority to do it to health departments and county mayors. These included ordering the closure of all businesses, except those the governor deemed essential. By the way, we did that here in Tennessee. He ordered churches closed, prohibited social gatherings. We did that, including weddings and funerals. Prohibited travel. We did that. And through the CHFS, even prohibited citizens from receiving scheduled services, surgeries, and access to medical care. We did that as well here in Tennessee. And then there is the order that everyone wear a mask. We allowed county mayors and health departments to do that here in Tennessee. These are undeniably attempts to control, set policy, and determine rights and duties of the citizenry. Guess who can't do that per the Constitution of the state of Tennessee? The governor and any member of the executive branch, because the Constitution says that they can't. So this court ruling just came down this week in Kentucky, just one state north, saying that everything that's happened in that state that we've been fighting against here in Tennessee is unconstitutional. Yet, here in the state of Tennessee, we can't even get a judge to take a look at our argument. We can't even get a court to give us our day in court, to give us a shot at justice against a tyrannical governor and a General Assembly who chooses to do nothing about it. So here's the court order from our case here in Tennessee. This is what the Chancery Court judge in Davidson County had to say. Plaintiffs fail to state a particularized claim for relief because they cannot show they have suffered a distinct and palpable injury specific to them and not shared by the general public. Let's clarify what this judge is saying, just to make sure you understand how crazy this issue of standing is. I sued the governor, and I claimed injury by the unconstitutional laws that were made by the governor of the state of Tennessee. What this judge is saying is that since my injuries are not distinct from the rest of the state, since we've all experienced injury, since the injury affects all of the citizens, it's not valid and it shouldn't be heard in court, because a large class of citizens are needed to establish requisite standing to challenge the constitutionality of Tennessee Code 582107, which is the emergency powers statute. And so here's what the judge says. The court declines to address our facial challenge to the constitutionality of the emergency powers statute. Tennessee courts do not decide constitutional questions unless resolution is absolutely necessary for determination of the case and the rights of the parties. Do you think maybe that all of the citizens of Tennessee have rights? And maybe it's important for the court to determine whether or not the state of Tennessee... This is the problem with this issue of standing that we have in our courts right now. Because they can use this issue of standing to simply throw a case out of court and decide that the government can do whatever it wants to do. You understand that, right? This is what this judge is saying. If a governor makes a law, which they can't do, or the legislature makes a law that's unconstitutional, well, by God, you can never get the court to hear anything about it because it affects everyone. And as long as it affects everyone, the court doesn't want to hear it. Do you realize what that means? It means, in effect, then, that the government can at any time always do whatever it wants to do. Because whenever it does something, it affects the whole of the people. So then you can never have standing to take something to court against the government. That's ridiculous. That is a ludicrous statement. That statement alone, and that stand by the court, is in itself unconstitutional. Which takes me to my last point. I'll leave you with this. And this is where we are right now in our appeal to the court to continue this case, is that we're still trying to argue that we have standing to bring this case before the governor. Interestingly, we found a statute that passed in the year 2018, just a few years ago. And it was run in the House by Representative Glenn Cassida, our state representative here in Williamson County. And it was a law actually dealing with this very subject to reinforce the fact that citizens in the state of Tennessee have a constitutional right to take their government to court and challenge the constitutionality of its laws. So here's the statute that's now current law in the state of Tennessee. Tennessee Code Annotated 13121. This was passed in 2018. Notwithstanding any law to the contrary, a cause of action shall exist under this chapter for any affected person who seeks declaratory or injunctive relief in any action brought regarding the legality or constitutionality of a government action. A cause of action shall not exist under this chapter to seek damages. So that law was passed by our General Assembly in 2018 to reinforce the fact that irregardless of whether or not a court is determining standing for an injury by the government, that every citizen in the state of Tennessee has a constitutional right to take its government to court and to challenge the constitutionality of its actions. Meaning, we're not required to have standing. Our standing is the fact that we're a citizen and we're saying that the government is acting unconstitutionally. Unfortunately, in 2018, this statute was actually taken to court, and here's what an appellate court judge had to say about it. Standing may not be predicated upon an injury to an interest that the plaintiff shares in common with all of the citizens. Again, this judge is making the same argument that our judge made in our case. Well, since everybody's affected equally, the plaintiff doesn't have standing and the court doesn't have to hear it. He goes on to say this. Our reading of the new statute is that it does not relax the particularized injury requirement for standing in cases brought regarding the legality or constitutionality of a governmental action. So this judge is saying that his interpretation of this law changes nothing. that standing is still required, even though the General Assembly passed a law saying that it's not. So I found this video, and this is what the court has to look at. This is called, and I'm sorry I'm getting long here, but this is important. This is called legislative intent. So it's important that you understand this. Courts, let me just set this up for you, make sure you get this. Courts don't make laws. I'm going to say that again. Courts do not make laws, which also means that courts do not get to make the law say whatever it is they want it to say. When trying to identify what a law says or what a law means, the court is required to go to the legislative intent of that law. Well, we found the legislative intent, so I want to show you a video. This is Representative Glenn Cassida from Williamson County on the House floor in 2018, submitting the bill for passage to the House, and this is what he had to say about the bill as it was being passed through the House.
Madam Speaker, this bill clarifies that citizens have standing to take government to court on a declaratory action. So I renew my motion.
All right, stop, because I want to make sure you're catching this. I'm gonna read this from my notes because this is what he's saying as he's introducing the bill. Again, this court opinion I read you just a minute ago says, oh, this new law has nothing to do with standing. Citizens still need standing to sue the government. They still need an injury. Well, here's what Representative Glenn Cassida said as he was introducing the bill. This bill clarifies that citizens have standing to take the government to court. That's literally the introduction of the bill. What he's saying is we understand that in many cases the court is saying that citizens don't have standing when they're challenging their government on the Constitution. So I'm going to read that again. The guy who ran the bill in the House, our legislators who passed the bill, are telling the court this. This bill clarifies that citizens have standing because they're citizens to take the government to court. All right, let's keep watching.
Mr. Leader, the breadth of this provision in Title I, Chapter 3, is this intended to apply across the board to any action against the government?
Declaratory action.
Or injunctive relief?
Or injunctive, but not
across the board.
That is the intent. We have a constitutional right to take our complaints to court on a government that doesn't comply with state law.
Representative Clemens?
I'm aware of that. I just want to make sure the intent of this legislation is as I understand it, which is the breadth. So if any cause of action against the government in the code or elsewhere does not currently contain a private cause of action, you're creating one with this legislation.
I would submit we're making it clear that it already exists. I think when we passed legislation in the past, lower courts have opined that citizens don't have a right to take their government to court. I contend on many occasions, we have made it clear that they do, but we're making it very clear.
Representative Clemens?
Well, you still have a standing issue. The standing issue, is that what you're trying to address? Or are you saying everybody, regardless if they're impacted or not, has standing?
No, I'm giving standing to the citizens in that particular jurisdiction so I'm giving standing. You're correct.
And so I want you to catch what just happened here. So you had Representative Clemens, who stood up, representative from Nashville, and he asked a question based on standing. I mean, he literally asked the question. He's wanting clarity. Leader Cassida, are you saying that we're giving everyone standing here? Because I understand typically citizens need an injury. You need something to satisfy standing. So he's literally trying to clarify that point. And here's Leader Cassida's response. We have a constitutional right to take our complaints to court on a government that doesn't comply with state law. How could he be? He's literally reinforcing the fact that, yes, we're granting standing. Why? Because citizens have a constitutional right to take their government to court. It's that simple. We have a right for a redress of grievances We have a right to petition our government. It's in our Constitution. It's actually in our Tennessee state constitution. So this is what's going on. These are the shenanigans happening back and forth in court. I remind you, we filed this lawsuit on August 27th of 2020. It's now June of 2021. And the court has refused to even answer our constitutional question. We are still petitioning the court just for our right to be heard, even though there is a state law on the books passed in 2018 that was passed to clarify to the court that citizens have a constitutional right to take their government to court and have the standing to do so. So that's what's happening. That's where we are. We are, because look, I don't know if you've realized this, we're done with 2021's legislative session. There is not one bill that came out of a committee in our General Assembly that would limit the governor's authority in an emergency or have anything to do with anything we've experienced coming from the executive, coming from the governor's office in an emergency declaration. So we're still in the same spot now as we were a year ago, should this ever happen again. And we are determined to not let that lie. And we're trying to see if we can get that done in the court. So that's what's going on. Stick with us. Keep following. We'll give you updates as we get them. And keep up the good fight. All right. Bye.